Hello everyone. Welcome back to my channel Study with Neha Mawa. So today I am back with another video on contract. So in today's video we are going to understand step further what is the contract and what are the special ingredients or special components in it. So without wasting time, let's get started. So I welcome you all who are here and who are watching my video. I request you all to subscribe to my channel and like my video and share with your friends. So in today's video, I am going to start the consideration under the Indian Contract Act. Now, we have studied so far about the contract, about the agreement, about the promise, offer and acceptance we will study later on. But in today's video, I am going to start with the consideration. Consideration is something that is in the monetary terms. Section 2, subclause D of the Act defines the term consideration as follows: when, at the desire of the promiser, the promisee or any other person, when at the desire of the promiser, promisee does something, then it is a valid consideration. Consideration means generally we consider the consideration in the monetary terms. For example, when you go to the market and when you purchase something or when you buy something, you will pay money in return to that. So that money is called the consideration. Consideration means when there are the two parties in a contract and one party promised to do a certain kind of act, then the another party or the another person in the party will pay consideration for particular act. So we have important case Kedarnath Bhattacharjee versus Gori Muhammad, 1887, Calcutta. Then a town hall was planned to build in Hora. Based on it, all the subscriptions, funds and interested persons came up for the construction. Municipal Commission of the Hora, the plaintiff entered into an agreement with the contractor and supplied necessary information about the plan. Later on, with an upswing of the subscription and plan, there was a rise in the cost of construction, making it from 20,000 to 40,000. Earlier it was 20,000, but after when the construction cost got very high, it became from 20 to 40,000. The defendant made a subscription to pay rupees 100 for the construction of town hall. However, he refused to pay the amount. Here, the main consideration was to pay the amount and that person refused to do so. So the plaintiff commenced an action to claim the amount. The court held that even if the defendant does not benefit from the promise he made for a charitable purpose, he is liable to pay the amount. He was responsible for his promise. A promise once made cannot be taken back after its commencement. Once you have said that, once you have promised that you will pay the consideration, you have to pay. But if you are paying that consideration for a charitable purpose, for example, a person, he promised a certain he promised a certain authority or an NGO to pay 40,000 rupees as charity, but after later on when the person refused to do so, they can't claim that person, they can't make that person liable for not paying the charity, because that was only a charity, that was not a contract that is in between them. So it reaffirmed the rule of law by stating that any act done at the will of the promiser wish is taken as the fulfillment of consideration of a contract. So overall it is concluded that the consideration here we are talking about means you have to pay for the act or for anything you have promised for. But when you are paying, or when you have promised to pay something for charitable purpose, it will not make that person liable if the person has not paid the consideration. Then we have the types of the contract here. We have the bilateral contract and unilateral contract. Bilateral contract involve two parties. Both parties are obliged to one party for performing or abstaining to perform any act. It is also called a two-sided contract as it involves two-way promises. So meanwhile, unilateral contract are those in which promise is made by only one party. So unilateral contracts are those where only one party make the promise, but in bilateral contract here the two parties both simultaneously makes the promise. They consist of an offerer and the offeree. Offerer means who offer for a particular thing. Offeree means who accept that. So offerer makes a promise to perform an action and is bound by the law to do so. So the offeree is not bound to the court even if he fails to execute, because first offer is made by the offerer himself. So because he does not promise anything at all, who promised? Of course the offerer. So we have express contract. These contracts are those wherein the terms of the contract are expressed clearly, whether in the written documents or orally. Express contract means when you are expressly expressing something, whether it is in a written document or whether it is orally, doesn't matter. Then we have implied contract. There is no oral or written terms in this type of contract. Implied means when it is assumed or when it is genuinely implied that you have to do so. If an individual visit a medical professional, he expect to be diagnosed for a disease or illness and be advised a cure. So this is an implied contract, and a patient is capable of suing a medical practitioner for malpractice. Then void and voidable contract. Void contracts are illegal from the very beginning and hold no validity under law in near future. They are thereby unenforceable. Void contracts are strictly prohibited by law, strictly forbidden by law. Voidable contracts are unlike void contract in the sense that one party is bound by the contract and the unbound party is capable to terminate the contract as they are unbound to do so. Voidable contract are those which were initially valid but later on they became void. Then we have general offer. A general offer is any offer which is not made to a definite person but to a public at large. General offer and a specific offer. General offer is generally made to public, that involves all the person, but specific offer means when the offer is made to a particular person. Say let's say A. So important case here we have Pharmaceutical Society of Great Britain versus Boots Cash Chemist Limited. When the goods are displayed either in a show window or inside the shop and such goods bear price tag, the question which arises in such a case is whether that amounts to an offer to sell goods at price mentioned on the price tag. So in this case it was held that, now what is the question? Whether that amounts to an offer to sell at prices mentioned. So what the court held, it was held that display of the goods along with the price tag merely amount to invitation. When you have you seen that when you go to the mall or when you go to the market, you will see the clothes they are hanging and they have the tag in it. So these tags just predicts the tells you the price of that particular thing, but they don't force you to buy that. It is just the invitation to the general public whether you want to purchase it or not, but it fully depends upon the discretion of that party whether they want to purchase it or not, but nobody is going to force you to buy that particular thing at any cost. So it was held that display of the goods along with the price tag merely amount to invitation to trade, and therefore if an intending buyer is willing to purchase the goods at a price mentioned on the tag, he makes an offer to buy the good. The shopkeeper has the right to accept or reject the same. So the contract would arise only when the offer is accepted. When you will go to the, when for example, when you go to the mall, you see a thing there along with the price, or when you accept that to purchase it, then it becomes the offer, then the actual contract between you and the seller will begin. Then we have, can a offer lead to a contract? We have a very leading case here. Carlyle versus Carbolic Smoke Balls Company. It's a very leading case in your whole Contract Act. In this case, a company carried out advertisement about their product, that is carbolic smoke balls, that claim that any person who took the smoke balls in the prescribed manner, let's say 3 times daily for 2 weeks, will not catch influenza. In case someone does, a woman actually does that, and the company promised to pay her 100 euro to them immediately. To show their sincerity regarding this offer, the company deposited a sum of 1000 euro in a public bank. Now the plaintiff Carlyle bought the smoke ball and used them as prescribed in the advertisement, but still ended up catching the influenza. She filed a suit for recovery of 100 euro as promised in the advertisement. Company denied the payment, saying there existed no contract between them and the plaintiff because it was not a specific offer to Carler, as it was a general offer to the public. It was the invitation. Those who wanted to accept it, it is a general invitation. But it was not the specific offer that is given to the Carler. So it was held that a contract came into existence between the plaintiff and the company as soon as plaintiff bought the smoke balls and used them as prescribed. So, so this was all about the second part of the contract. So in the this was all. So in the third video, I will come up with the offer, acceptance, promise, each and everything. So in this video it was all about the consideration, some of the case laws, and some of the contracts and the types of contract and the general offer. Hope you all liked my video. Please do subscribe my channel, like my video, and share with your friends. Thank you and bye bye.